Well, Zuma named people he accuses of using the commission to discredit him. He also denied any involvement in wrongdoing and accused the commission of cross-examining him. His legal counsel said the commission was victimizing him. Now, to discuss the mandate of the commission as well as its procedures following Zuma's allegations of victimization, we're now joined from our Cape Town studio by Christine Botha from the Centre for Constitutional Rights. We also have legal expert Nthabiseng Dubazana in studio with us. Christine, let's start with you. We had this to and fro this past week. Zuma was testifying, then he withdrew, then he was back. Who won this round this week, Zuma or the Commission?
I think it's important to start off by saying, what is the purpose of a commission? The purpose of a commission is to investigate, to make findings and recommendations. So this is not a court of law. And this relates to Zuma's legal term specifically said, well, you know, he's being cross-examined. And if we analyze that statement, you need to properly look at what the commission was supposed to do. So they presented him with specific witnesses' statements who implicated him, and they requested him to give his side of the story. So this is not a matter of cross-examination. So going back to your question of who won this round, it is not a matter of who won this round because it's not a court of law. He will eventually need to come and respond to those statements where he was specifically implicated. And that's where you have to look at the Commission's procedures. A chairperson can specifically summon him as well to come and appear. In this case, they've requested him now, and he's agreed. So he's been given implicated statements, and he will need to respond.
Nthabiseng, the Commission said it won't send questions to Zuma. It will now highlight areas of interest that it wants him to answer to at a later stage. But isn't this kowtowing, though? He's been given more time as well. It just seems a bit like the Commission said, bowed a bit to him and said, okay.
Well, like my colleague just said, the commission, when you are going to be implicated in statements that are going to be made on the commission, you are giving them beforehand, before the person comes and testifies, right? And you're given the opportunity, 14 days to be precise, to respond, to make a decision whether you're going to come to the commission and have an oral response, or you have a written response to those allegations that are made within those statements. So there's been about 9 or so witnesses that have testified thus far who have implicated him to this date. So all those 9, he had those statements prior to him appearing onto the commission. So now, at this stage where we are at, I feel that it is not bowing down to him and accepting his terms. It's not like he was summoned or subpoenaed to come. It was a courtesy for him to actually be there. And the rules of the commission that are made is that there is no need for the witness who is not necessarily subpoenaed to testify, to be cross-examined, I beg your pardon. But it will be according to the head of the commission who will decide how the questioning will be done. And that person, that witness, is afforded the opportunity to know what the line of questioning is going to go through so that it doesn't prejudice him in such a bad way. So it's not bowing down. It's actually following onto the lines of what the commission's rules and procedures are.
Christine, Zuma's lawyers claim he was being treated like an accused at a trial. Was he, or was the Commission being fair in its questioning?
Okay, this is again important to understand for the public. This is not a court of law. This is not a criminal trial, which he needs to, respond to a charge sheet. He needs to plead to a charge sheet, or a civil trial. This is a commission who has to investigate. It has investigative purposes. So he's given an opportunity to say his side regarding where he was implicated. So the commission, Mr. Zuma's attorney specifically said he was cross-examined. But I think by using the word cross-examination, they confusing the public perhaps as well, because cross-examination is a specific procedural aspect. So you would first have a witness coming in and giving in evidence in chief. That's what happened now in a court of law. So he'll present his case, and you'll have questions being asked to him, and then the other side will cross-examine him on his evidence. And there will be an opportunity again for re-examination. We haven't seen, this is definitely not what has happened here. There isn't a statement by Mr. Zuma on his version of events. We don't have a statement. That's a very important aspect to understand. He could have, that specifically provided for in the rules, he would have needed to apply to the commission before before those witnesses gave their statements. And he could have said, listen, I want to give evidence myself, I want to cross-examine, and he would need it to have apply. There was no such application. So going back to the type of questioning, it was just to show his side of the events, to hear, okay, Mr. Zuma, this is what Mr. Maseko says. What do you say about it? If it happened, would it have been natural? There is no case to be made against Zuma here, so it's not a matter of cross-examination. And I think that's very important to understand. And evidence need also specifically pointed out in yesterday, just explaining the difference in, it might be a difficult question requiring details, but it's not cross-examination. Cross-examination means there needed to be evidence in chief. He needed to give evidence first, which would have been led by his own counsel.
And Nthabiseng, in any case, I saw that within the scope of the commission, there is an allowance for examination. Now, I'm not sure what the difference between examination and cross-examination is. Perhaps you can explain that to us, but it does mean that there is allowance for a certain kind of questioning.
That is very true. There is an allowance for questioning. The kind of question is always directed by the head of the commission, so that it can be for purposes of getting what is the truth based on evidence that's been given by witnesses, especially if somebody is going to be implicated. So now, to answer what examination, she basically kind of broke it down. But examination in chief is whereby you first lead your evidence. So, for example, in a criminal court in setting, the state starts, let's, for argument's sake, Oscar Pistorius case. That's always the one that comes back to me because it was in media. So now, when the state presented their evidence, their witnesses to what happened on the day of events, their experts and stuff, that was their evidence in chief, those state witnesses. And then when Oscar Pistorius' attorney came in and cross-examined, it's because there is a statement or evidence that's already been placed before the court, saying, okay, now, you have said 1, 2, 3, 4, but what I have is this. That's how cross-examination works. We need to understand, based on your examination in chief, and based on the statement that you had made that is commissioned and already in the docket, and now whatever you will say under cross-examination to determine what the truth is. That's how cross-examination would work during a criminal trial. So I hope that kind of explains the aspects of examination in chief and cross-examination. Here, it's just a line of questioning to clarify what is the truth, what happened. Somebody, Mr. So-and-so said this about you, what says you? And then if there's a need to delve deeper into the question and get specifics, that's what they're looking for, get specifics, then they have the right to do so as long as the head of the commission has endorsed that line of questioning.
Christine, let's take a look at Zuma Strategy. Apart from his opening statement, we learned very little this week with him basically saying he doesn't know, he doesn't recall. If you were one of his lawyers, is that the advice you'd give to him, to just say, well, I don't know?
Well, listen, it's difficult to say. I'm not his lawyer. I think I've got a difficult case as well because, the commission could have summoned him to appear as well. He agreed to appear. So answering your question, I would have said, listen, the regulations say you can't refuse to answer unless it falls under the law of privilege in terms of the Commissions Act. So unless you give him very specifics, he can just say, well, I can't recall, I don't know, and that's definitely what we see here. So you would need to narrow it down to documentation, and this is just my personal, need to narrow down the type of questioning, see if he could give you more information. But again, it's not a case to be built against him. You're just hearing his version as well.
But Nthabiseng, so obviously, I mean, we're looking for information. We're looking for some answers. We've had some very serious allegations being made against Zuma by the 9 other witnesses. If you were advising him as well, would you say to him, okay, it's better to say that you're vague on the details?
Considering that he's here to clear his name, for lack of a better term, and to answer to the allegations that were made against him by the other witnesses, I think it would be best to answer the questions in accordance to what he knows. If somebody says they don't know, what more can you do? You can't probe anymore. It's not like he's refusing to answer the question. We can assume he's being honest enough to say, I do not recall what happened. So the best advice I would have given him if I was going to be there is like, this is what so-and-so said. What do you recall? Go through every single witness's statement that has been placed before you, because he has the hard copies with him. Go through everything and then prepare yourself for the possibility of a certain question being asked based on those statements that you have in front of you. And then when the commission legal team asks you questions, then you're more or less prepared. But if you have no recollection, you have no recollection. It is an acceptable response at the end of the day.
Is there something that the Commission can do to get better answers out of him? I'm not sure if that's possible. Well, because right now we've got he said, she said situation. You've had the witnesses say these things, but we've got very little evidence besides the testimony of these witnesses to back up what they've said.
No, I don't think that there's much that they can do, because at the end of the day, this is not a trial court. Because if he was saying such things in a trial court and he's in the witness box, he'll probably be declared a hostile witness, because he's refusing to answer the questions. That's when probably the court can now see if they can compel you to answer questions, because what are you saying? You don't know. And then at the end of the day, when you are found guilty, when you appeal, it's going to be a lengthy process. But here it's just a commission of inquiry. And you must remember that everything that is being said and evidence that's being placed in this commission cannot be used to open a criminal case or any case, well, specifically a criminal case. So if the state is watching, for example, which I know they are, the NPA is watching, they can't use what they're hearing here. They really cannot. What they will do is probably, if they now heard what happened in the commission, start their own investigations and actually bring tangible evidence to the court in order to open a case against Mr. Zuma. I think that's why it's been basically hanging for the last 15 or so years, because there's no tangible evidence to say that he is linked to all these cases that have been brought against him. So, yeah, that's where it stands.
Christine, doesn't this speak, though, to the concerns that the Commission is somewhat toothless? If it can only have these he said, she said situations where you've got one witness saying one thing and then the other witness saying the exact opposite with no tangible evidence being brought, what are you going to end up with at the end of the day?
I think, again, we have to take stock of how big this matter is. There's so many witnesses who've come forward and given their versions and evidence as well, and there are documentary evidence also handed in. So again, I would definitely not say it's a toothless commission. It has the power and it will probably only do so after an inquiry, to refer matters for prosecution. But exactly as my colleague said, no self-incriminating evidence can be used against that person in the criminal trial. So that's against that person, unless he perjures himself, for instance. And you notice, well, he lied in front of the commission, and that could be a possible way. So I think, again, we need to know the facts, and there's so many versions and evidence coming forward, and it will be an investigative team to sift through it and to see, okay, this is what we could find, And this is our facts and recommendations. I mean, there could be various recommendations also coming out of it, seeing what loopholes should be closed in governance to ensure it doesn't happen again. So I think we need to be realistic of the Commission's purpose. It doesn't mean independent investigations shouldn't have occurred already. I mean, there's evidence is out there. The NPA and the Hawks should, and I assume they're working very, very hard on state capture cases. They can't use self-incriminating evidence given at the Commission, so that's clear. But those investigations should be taken place already.
All right.
And matters should be prosecuted, so hopefully.
Absolutely. That's Christine Botha from the Centre for Constitutional Rights, as well as legal expert Nthabiseng Dubazana. Thank you very much for your time.